Today, we're pulling back the curtain on something absolutely fundamental to our legal system. You see, when Parliament writes a law, how do judges figure out what they really meant? It's a fascinating journey.
So let's just dive right in. What does a law really mean? You might think it's as simple as reading the words on the page, right? Black and white. But it's really not. There's this whole web of history and purpose, and even human rights that judges have to navigate. And make no mistake, how these laws are interpreted, that directly impacts your rights and your obligations every single day.
And right at the heart of this entire story is this huge constitutional tension. On one side, you've got parliamentary sovereignty. That's the bedrock principle that Parliament has the supreme, ultimate power to make our laws. But on the other side, you have judicial interpretation, the crucial job of the courts to take those laws and apply them in the real world. And that creates this constant, really fascinating balancing act.
All right, so here's our roadmap for today. We're going to start by setting the stage, then we'll travel back in time to an era when the written text was absolute king. From there, we'll see how judges started searching for a deeper purpose. Then we'll explore the game-changing human rights revolution, and we'll finish up by looking at the incredibly delicate balancing act they perform today. So how exactly do judges walk this tightrope? Well, the first thing to know is there isn't one single fixed rule. It's not like a math formula you can just plug in. Instead, over centuries, they've developed a whole toolkit of different approaches to try and balance what the law says with what Parliament actually intended. Let's start with the most straightforward and, honestly, the most rigid approach. We're talking about an era where judges saw their role as almost totally subservient to Parliament. Their job was just to apply the text exactly as written, no questions asked. And this is called the literal rule. The idea is simple. If the words of a law are clear, you apply them, period. But here's the real kicker. You did this even if it led to a completely harsh or absurd result. The number one priority was certainty, sometimes, at the total expense of common sense. And to see just how wild the real-world impact of this could be, you don't have to look any further than this case from 1836. During a fight, a defendant did something pretty horrific. He bit off the victim's nose. But here was the problem. The law at the time, when you read it totally literally, only made it a crime to do these specific things: to stab, cut, or wound. You see what's missing there, right? And so, the verdict was shocking. No offense committed. Why? Because the act of biting didn't involve an instrument, so it didn't literally fit the words stab, cut, or wound. This was a complete failure of justice that showed how sticking rigidly to the text could totally defeat what Parliament obviously intended, which was to stop people from being seriously hurt. An outcome like that just screams out for a better approach, doesn't it? So, judges developed a slight modification, a kind of safety valve, if you will, known as the Golden Rule. This allowed them to step away from the literal meaning, but, and this is a big but, only when following it would lead to a completely absurd result. Okay, here's a great example of that. A law made an offense to be in the vicinity of a prohibited area. So, in this case, a protester was actually inside an RAF base. Now, if you take that literally, being inside a place isn't in the vicinity of it, it's just absurd. So the court used the Golden Rule to say, look, in the vicinity has to include being inside the place too. It's just a common sense correction. So this kind of thinking just kept evolving. Even with the Golden Rule, judges were mostly just patching up clumsy wording. The next stage, though, marks a huge philosophical leap. They started asking not just, what did Parliament say, but, hang on, what problem were they actually trying to fix here? And this brings us to something called the mischief rule, which, believe it or not, goes all the way back to 1584. In this context, mischief just means the gap or the problem in the old law that Parliament wanted to fix. The judge's job then becomes a bit like a detective's: figure out what was wrong before and then interpret the new law to fix that specific wrong. A classic example of this is a case called Smith v. Hughes. A law was passed to stop prostitutes from soliciting in a street. But in this case, the women were actually calling out to men from windows and balconies, so literally they weren't in the street. But the court applied the mischief rule. They asked, what was the real mischief here? Well, it was the public nuisance of solicitation. So they ruled that the law still applied because its purpose was to stop people on the street from being harassed, no matter where the call came from. So you can really start to see this evolution taking shape. You have the old mischief rule from way back, then the literal rule really takes over in the 19th century. Then in the 20th century, you see this shift towards a broader purposive approach, and then Boom, a revolution with the Human Rights Act.
Now, the purposive approach is basically the modern souped-up version of the mischief rule. Here, the courts look beyond just one specific problem to try and understand the act's entire philosophy or purpose. The idea is to fill in the gaps to make the law work the way Parliament truly intended, even if they didn't spell it out perfectly.
And here is a perfect modern example of its power. A law regulating human embryology was written before human cloning was a thing, so it only mentioned embryos created by fertilization. Now, clone embryos aren't fertilized, so a literal reading would mean the law doesn't apply to them. But the court took a purposive approach. They decided Parliament's overall goal was to regulate the creation of all human embryos, and so the law had to cover the cloned ones too.
But if we're going to talk about really big shifts, paradigm shifts, we absolutely have to talk about the Human Rights Act of 1998. This wasn't just another rule in the toolkit, this was a complete game changer that fundamentally altered the role of judges in the UK.
The incredible power of this act really comes down to this wording right here. Section 3 puts a direct duty on judges. They must read laws in a way that is compatible with human rights. And that key phrase, so far as it is possible to do so, well, that's a very strong and very direct instruction coming from Parliament itself.
And this duty gave judges some powerful new tools. They could now read down a law, basically narrowing its scope. They could read in words that weren't even there to make it compatible. Or they could even read out, just ignore, problematic words. These are not minor tweaks. This can fundamentally reshape how a law works.
Just look at this incredible example. The Rent Act gave tenancy rights to a surviving partner who was living with the tenant as his or her wife or husband. Now, that wording clearly implied a heterosexual couple. But the House of Lords used Section 3 to effectively read the law as if it said as if they were his or her wife or husband, which extended those rights to same-sex couples to prevent discrimination. They literally altered the meaning of the act to protect human rights.
Which, of course, brings us to the biggest question of all. Does this mean judges are now challenging Parliament's sovereignty? With powers like reading in words that aren't there, are they effectively making new law? It certainly feels like a massive shift in the traditional power balance. But, and this is so important, there is a vital safety net built in. If a law simply cannot be twisted or interpreted to be compatible with human rights, the judges can't just strike it down. Instead, under Section 4, they issue what's called a declaration of incompatibility. Now, the law stays valid, but it sends this powerful political signal to Parliament that, hey, this needs to be fixed. So it preserves Parliament's ultimate authority while creating this formal dialogue about rights. So from the rigid, sometimes absurd, literal rule all the way to this complex, rights-aware dialogue, we've seen a pretty dramatic evolution. It shows that judges are in this constant state of striking a delicate balance between Parliament's words, the law's deeper purpose, and fundamental human rights. Which leads to one final thought for you to take away. How does this incredibly complex judicial balancing act affect the kind of justice you hope to see in your daily life?